Hello, everybody. Thank you for joining our press conference this today. Um, on with us today, we have New Jersey Attorney General Matt Platkin, California Attorney General Rob Bonta, Delaware Attorney General Kathy Jennings, Illinois Attorney General Kwame Raoul, and Rhode Island Attorney General Peter Neronha. And I'm going to turn it over to Attorney General Platkin to start this press conference.
Thanks, Mike, and thanks everyone for getting on. I'm proud to be joined today, as Mike said, by Attorney General Bonta of California, Attorney General Jennings of Delaware, Attorney General Raoul of Illinois, and Attorney General Neronha of Rhode Island to announce a lawsuit against the federal government for holding hostage over $1 billion in funding that goes directly to support victims of some of the most heinous acts anyone will ever endure. VOCA funds have been in place and untouched, supported by presidents and members of Congress of both parties for over 4 decades. The law was first put in place by Ronald Reagan after a study of how victims of crime were treated in this country uncovered widespread systemic failures in how we support those who have endured these unimaginable traumas and how we provide them services and relief to help them get back on their feet, and how we help them navigate a complex, often scary, and sometimes traumatic criminal justice process so that we can seek justice on their behalf. Just about every law enforcement agency in the country relies on these funds. They have never before been subject to the political whims of a president until now, when President Trump and his administration, Attorney General Bondi and her department, without warning, told us, the 20 states and District of Columbia that are joining this, without any consideration for how it would affect us or the victims in our states, that they were going to unlawfully condition these grants on separate and wholly unrelated policy preferences of the administration when it comes to immigration enforcement, policy preferences that have repeatedly been upheld in the federal courts, and trying to use strong arm tactics to make states bend the knee in ways that courts have repeatedly told them they cannot do. In this case, the political pawns that they're using are victims of gun violence, victims of domestic violence, survivors of sexual assault, children who have been sexually abused, people who have been victims of armed robberies, and I could go on the list. People that all of us on this call have dealt with, have fought for. We know their families. We've seen the impacts of these funds. In New Jersey, if these conditions were allowed to stand, these unlawful conditions, the upshot would be that thousands of people in our state every year would not receive services and funding for things like housing, psychological support, emotional support, compensation for lost wages. I could go on. Millions of people would not receive the benefit of the services that our law enforcement agencies provide in order to help them come forward and help us seek justice on their behalf. And then you can multiply that out across every state across this country. And it's yet the latest example of an administration that talks a big game about law and order, but has been the most anti-public safety administration, I think, in modern American history. Started on day one, pardoning 1,500 people who violently raided the United States Capitol, resulting in at least one law enforcement officer losing their life, somebody who was born and raised in the state of New Jersey, Officer Sicknick. Continuing the following week when they froze trillions of dollars in funding, including, as many of us experienced, funds for things like tackling the drug cartels in our states, something I thought was a priority. In a separate lawsuit that we've had to file, they unlawfully cut funding for prosecuting bias crimes and installing things like license plate reader technologies that help us tackle violent crime. And now this, what I think is maybe the most heinous act I've seen in politics, a president, an attorney general using victims of crime, victims of violent crime, victims of domestic violence and sexual violence and gun violence as political pawns. These people did not ask for this status as a crime victim. They don't break down neatly across partisan lines, but they share one common trait, which is that they've suffered an unimaginable trauma. which is why, as a country, 4 decades ago, we came together and said we will put in place a system that provides support for them and helps us achieve justice on their behalf. This president, this attorney general, for the first time since Ronald Reagan was president, is threatening that policy and that program that millions of Americans have relied upon to get back on their feet. We won't stand for it. As a coalition, we are seeking a declaratory judgment to say these conditions, as courts have said repeatedly in multiple contexts, are unlawful. And we will not allow them to put politics ahead of public safety. It's now my honor to turn the mic over to Attorney General Rob Bonta from the state of California.
Thank you, AG Platkin, and good morning, everyone, and good afternoon. Rob Bonta, California Attorney General here, and I just want to first thank our host, my friend and colleague, AG Platkin, and the entire coalition of 21 Democratic Attorneys General who are standing together in this lawsuit. Once again, proud to stand with the Democratic AGs, upholding the rule of law, defending our Constitution. Democratic Attorneys General are yet again fighting for the rights and safety of the residents in our states. We're fighting for law and order and upholding the U.S. Constitution. And unsurprisingly, Republican attorneys general are nowhere to be seen. Republican attorneys general are yet again abandoning the states and people they serve and the oaths they swore out of blind allegiance to Donald Trump. If our Republican counterparts took one honest look at this case, they'd see what we see. The U.S. DOJ and U.S. Attorney General Pam Bondi have broken the law. They've trampled over the separation of powers, a fundamental principle of our democracy. They're putting public safety and survivors of crime at risk, and they're holding over $1 billion of federal funding hostage to strong-arm states into joining their inhumane and frenzied immigration agenda. We won't be bullied or manipulated by the Trump administration. The Victims of Crime Act has absolutely nothing to do with immigration enforcement, nor should it. Congress created and has consistently voted to fund the Victims of Crime Act to help states support survivors and witnesses of crime, to provide resources and services to help those in need recover from trauma, move forward on their path to healing, and restore normalcy to their lives. Each year, VOCA helps nearly 10 million victims and survivors. California alone is expected to receive over $165 million this year to help support 35 programs across the state, including California DOJ's own Victims Services Unit, or VSU. Our VSU team works tirelessly to serve, support, and empower each victim and survivor who reaches out to our office. Their work is undeniably critical, often irreplaceable, and deserves our unequivocal support. Take, for example, the VSU advocate who helped a victim find and connect with the correct local law enforcement agency to track down her sexual assault evidence kit, while also providing resources to mental health agencies and other support systems in the individual's local area. Or consider the DOJ advocate who helped an individual who had been subjected to revenge porn years earlier when they were underage. The advocate met with the individual in person and escorted her to our nearest office and then to the local police. When the individual was later directed to the FBI, she asked the VSU advocate to accompany her for emotional support. The advocate was able to provide crisis intervention during the process and continued to serve as a trusted liaison between the individual and law enforcement. Be it sexual assault, robbery, a hate crime, or domestic violence, our VSU team is here to provide client-centered, trauma-informed, culturally sensitive services to help survivors heal, to ensure survivors can connect with a real person who can explain what's actually going on in a language they know and understand, to ensure no survivor walks the road of recovery alone, because we know that healing is a critical part of justice. I'm proud of the work our team does, and fortunately, I know there are many other programs around the state that complement what they do. Programs like the Victim Witness Assistance Centers at district attorneys' offices that provide crisis intervention support, emergency assistance, court escorts, and counseling. In the 2023-24 fiscal year, that program served nearly 280,000 individuals. Programs like the Domestic Violence Assistance Program, which helps non-government organizations throughout the state provide emergency shelter, food, and clothes to survivors of domestic violence and their children. In the 23-24 fiscal year, that program served nearly 119,000 individuals. These are individuals who've survived traumatic, tragic, dangerous circumstances and deserve every opportunity to move forward, regardless of where they're from. By supporting victims and witnesses, regardless of their immigration status, BOCA helps individuals and families, and it builds trust between the community and law enforcement. That's vital to protecting our public safety so that when someone does experience or witness a crime, they feel safe to report it to law enforcement without fear of deportation. In California, the California Values Act, SB 54, ensures that we focus local and state resources on public safety, not immigration enforcement. That separation between state and local law enforcement and federal civil immigration enforcement promotes trust and ensures law enforcement can do their job of keeping our communities safe. Trump tried to challenge our law during his last term, and he lost. Now he's coming at us again, punishing states for prioritizing public safety, forcing us to choose between forfeiting funding for survivors and victims and surrendering to unlawful immigration conditions. The Trump administration is trying to leverage vulnerable people to force states to capitulate with its immigration agenda. Pulling funding from victims of crime isn't just immoral, yes, it's illegal, which is why our coalition is taking Trump and Bondi to court again. This is just the latest example of Trump's attempt to sideline Congress and bully states into doing his bidding. Congress, not the president, holds the power of the purse. They determine where funding goes and what conditions are put on it. They've been clear and they've been consistent ever since President Reagan's administration issued a report back in 1982 stating that the neglect of crime victims is a national disgrace. That's a quote. Congress has acted to do better. They voted to help crime survivors and witnesses, including children who need and deserve support as they heal and recover. Congress has never put civil immigration enforcement conditions on this funding because it has nothing to do with immigration. This is a brazen abuse of the president's power, and we will not sit idly by and allow it to continue. We won't allow Trump and his allies to violate the law and jeopardize the safety and well-being of our people. Before I close, I want to reiterate my appreciation for this amazing coalition of Democratic attorneys general, as well as for the members of my team at California DOJ who worked diligently on this lawsuit. For us, the 39th our office has brought and filed in 30 weeks. Again, more than 1 week. While they don't do it for the glory, they deserve to be recognized for their service. So let me recognize and thank Christina Gutierrez, Heidi Joya, Brandy Doyle, Luke Friedman, Dalen Thrift Viveros, Newton Knowles, Lee Sherman, Delbert Tran, James Stanley, Joel Marrero, Michael Newman, and Jackie Gonzalez. With that, please allow me to now turn it over to my colleague from Delaware, Attorney General Kathy Jennings.
Oh, Attorney General Jennings, I believe you're muted.
All right, I'm good. Thank you. Thank you, Attorney General Rob Bonta, and thank you to my fellow attorneys general today on this webinar and press conference, as well as those attorneys general throughout the country who have joined us in this important lawsuit. Today, we are standing up for victims of violent crime and for public safety in our communities. We are standing up for a criminal justice system where witnesses feel safe calling the police, where survivors have lifelines that they can trust, where our constituents in their darkest moments are not left to wonder how they will afford to rebuild their lives. We are standing up for the rule of law, which this president is once again subverting with no regard for who he hurts. This lawsuit is about one thing: protecting victims of crime. In Delaware, more than $15 million in funding for survivors, families, shelters, and service providers is at stake. We will not allow those services to be taken away from those who need them the most. VOCA is a bipartisan project, an agreement that part of public safety is bridging the gap for people whose lives have been shattered. It is the least we can do. Now those survivors, the mothers, the fathers of murder victims, paying for a funeral, the victims of domestic violence, looking for a safe place where their kids can sleep at night, the shift worker who chose caring for a loved one over a day's wages are being made into hostages for a political agenda. It is cruel, it is shameful, and it is illegal. These are not just dollars, they are shelters, they are hotlines, they are therapists, they are advocates, they are funding for rape kits, they are funding for new locks on broken doors, and they are medical expenses. The president talks a lot about how dangerous immigrants are. These funding cuts, or the red tape we would need to avoid them, would empower actual criminals. They would overwhelm law enforcement, and they would make it even more frightening for victims of crime to come forward for fear that they would be rejected, or worse, falsely identified, denied due process, and deported. In his effort to manufacture a violent crime crisis, the president has determined that his agenda is best served by leaving victims high and dry, by creating a self-fulfilling prophecy of an ineffective government, taking away the existing tools to help those who need us the most. I want every survivor in Delaware to hear me clearly. You have been through enough already. We will not let these funds be taken from you. We will not allow Washington politics to decide whether you deserve help. Delaware is proud to co-lead this fight alongside our colleagues across the country. Together, we will protect these funds, protect our communities, and protect victims of crime. For decades, as a prosecutor and now as Attorney General, I have sat with the families of murder victims in their homes and in our offices and in our courtrooms. I have listened to victims of domestic violence, sexual assault, and other violent crimes tell me their stories, and I have assured them that we will seek justice, we will protect them, and we will care for them every step of the way. This president is taking all of that away. We cannot let him do this, and that is why we have filed this lawsuit. We will fight, and we will fight hard for their rights and for their protection. Thank you so much for listening to me. I will now turn this over to my colleague and my friend, Illinois Attorney General Kwame Raoul.
Thank you, Kathy, and thanks to all my colleagues. I started my legal career as a county prosecutor and have dedicated much of my career to helping victims of crime. And that has been central to my focus as Illinois Attorney General. Unaddressed trauma endured by victims of violent crime is frequently a major contributor to the future violent criminal acts. This makes providing support to survivors of crime some of the most important work my office does. My office's Violence Prevention and Crime Victim Services Division helps victims and families on their road to recovery by helping them access trauma-informed programs and services. The Federal Victims of Crime Act, VOCA, has existed for over 40 years. VOCA funding is essential to our ability to support victims around Illinois. Illinois uses crime victims' compensation funds to reimburse victims of violent crimes such as homicide, human trafficking, child abuse, sexual assault, and others. My office has worked to make crime victims' compensation more accessible and more impactful for victims in Illinois. And between 2022 and 2024, my office recommended more than $38 million in compensation to Illinois victims. Illinois also relies on another VOCA formula grant, the Victims Assistance Formula Grant. Illinois anticipates receiving over $46 million from this grant for fiscal year 2025. We direct these victim assistance funds to organizations that provide vital, direct services to crime victims. These include domestic violence shelters, sexual assault crisis centers, transitional housing services, child advocacy centers, and trauma recovery centers. For fiscal year 2025, over $1.2 billion in victim assistance formula grant funding is available to the states at large, and over $178 million in victim compensation formula grants is available to the states. Conditioning that vital funding on cooperation with immigration enforcement is not just unlawful, it is immoral. VOCA funds have no relationship to civil immigration policy. In fact, grants are distributed based on a statutory formula that has nothing to do with immigration. Furthermore, immigrant communities have an important role to play in helping states reduce crime. The administration's policies make immigrant victims and witnesses of crime reluctant to cooperate with local law enforcement. This undermines public safety. Even as the president laments the rampant crime he claims is taking over our cities, his Department of Justice is threatening to withhold money that helps states address violent crime. The Department of Justice does not have authority to impose immigration conditions on these funds. The Constitution does not permit the department to impose such conditions. We filed this lawsuit seeking to prevent the department's arbitrary action. We cannot become complacent to the cruelty that has been the hallmark of the Trump administration. Just as we will continue to do the real work of ensuring the public safety, we will not stop fighting the illegal policies coming out of the White House that undermine the same. Now I would like to introduce and pass it on to my friend and colleague, Rhode Island Attorney General Peter Neronha.
Thank you, Kwame, and I want to thank all my colleagues. This office, the Attorney General's office in Rhode Island, has multiple duties. We are effectively the district attorney for the state of Rhode Island, much like my colleague Kathy Jennings in Delaware. But that is unique to our criminal justice system across the country. What that means is that we work with victims every day. I have been not only Attorney General here for the last 7 years, but I was an assistant Attorney General here. I was an assistant United States attorney, and I was the United States attorney. And so I've seen not only victims impacted by crime, but I've seen how immigration matters are handled from both the federal perspective and the state perspective. And I want to be very clear that this state and my colleague states, we cooperate with federal law enforcement when it comes to criminal, undocumented people in our states. There is no question about that. And that has been the case for decades. When a person who is in the country is undocumented and they are committing criminal acts, we are investigating, arresting, and prosecuting them and sending them to jail when necessary. That's what we do. And so this case isn't about a lack of cooperation with the federal government when it comes to law enforcement. That's not what this case is about. And I will say that the policies that the state of Rhode Island has in place have been in place for over a decade, in part required by a federal court ruling. And I was U.S. attorney during that period of time. And at no time when I was U.S. attorney or an assistant U.S. attorney did we have any difficulty in enforcing federal law vis-a-vis state policy. So the notion that there is such a problem is a trumped up stalking horse, straw person to try to force states, to strong arm states to do the federal government's civil immigration law bidding. And that is not something that we are set up to do. We need our state police and our local police departments investigating violent and other crime. That's their job. That's what they're trained to do. And that's what they should be doing. And the administration would have it be otherwise. Well, that is our decision to make as sovereign states, that we will use our federal dollars that we send to the federal government, that we as taxpayers, that's what we do. We want to use those monies as we determine they should be used. And Congress, as my colleagues have stated, by making these formula grants, have decided exactly that we are the decision makers as to how these funds are used without strings attached. Now, the president would add strings. And those strings, again, would require us to use our law enforcement resources in a way that does not serve our citizens best. I want to give you some examples of what these funds mean to Rhode Islanders. 41,000 Rhode Islanders in 1 year alone were assisted with these funds, nearly 5% of our population. For those listeners in Rhode Island, what does that mean? Where do those monies go? In part, they go to places like Day One to support children who are the victims of sexual assault. It goes to the Coalition Against Domestic Violence that supports victims of domestic violence. And I will say that I strongly believe, and it is part of my value structure, that when a 6 or an 8-year-old child is being interviewed at the Child Advocacy Center as to whether or not she was sexually assaulted by an adult, one question that should not be asked is whether that child is in this country lawfully or unlawfully. What the focus should be, and what the focus is here in Rhode Island, and I know it's true in my fellow states, is taking that child molester off the streets and providing safety and recovery for that child. That's what we care about here in Rhode Island. And in my view, the federal government should care about exactly the same thing. Thank you.
Thank you. So now we'll open it up to Q&A. So for the media on the call, you can raise your hand if you have a question, and we will unmute you. So we're perfect. All right, our first question is going to be from Nancy Lavin. You're unmuted.
Hi, thank you. I'm Nancy with Rhode Island Current. This is for whoever wants to answer, but I'm wondering about the timing of filing this lawsuit now. If the memo from the office, saying that they're going to withhold funds was put out in July, and it looks like the deadline to apply for these grants is in 2 days.
Thanks, Nancy. I think, and I'll let Attorney General Neronha jump in if since you're from Rhode Island, but I think as with every action that this administration takes, we assess what they're doing, what our legal basis is, and we pursue accordingly. I would note that one of the things we're challenging in this suit is the fact that they didn't even bother to ask us or ask any state or any victim or any service agency how these cuts would impact them. Again, this is the first time in the history of these grants that anyone has threatened to withhold them on any basis, let alone an unlawful one. So we are timely filing this case and seeking a declaratory judgment in time to get relief prior to the filing deadline. Thank you.
So can I just ask one follow-up, which is, are you looking for a declaratory judgment before August 20th or before the September award of funds?
Well, we're seeking a declaratory judgment as quickly as the courts can provide it, and we're also seeking vacatur of the policy that they've put in place here.
Thank you.
Thank you. Our next question will be from Sarah Mueller.
So I'm just wanting just, I'm a little confused. Has this money already been appropriated, or is this money that the states still have to apply for and get, approval of?
Thanks, Sarah. So Congress has the power of the purse. They appropriate this funding as they've done since the mid 1980s every year. The Department of Justice, through an office within the DOJ, then administers the grants, but the executive branch can't overwrite the statutory terms that Congress puts in place and impose new and unrelated conditions on those grants as a way of weaponizing them against the recipients. So they are administering the grants, but Congress is the one that put the grants into law.
So Sarah, this is Kathy Jennings. Thanks for your question. And Attorney General Platkin is absolutely right about this. Congress passed this law, and the funds are routinely appropriated as a result of that. And our lawsuit takes the position, it is the right position, that the president cannot interfere with that funding that has been legally appropriated for decades by Congress.
Yeah, and if I could just jump in here, I mentioned formula grants, and what that means is that, based on some very simple principles, mostly population, every state gets its share. And so the Department of Justice is really just a pass through to get that money to the states. And as our complaint points out, that has been the case since 1982, when President Reagan said, I think, very thoughtfully, and he was spot on, that our neglect of victims in this country has been a national disgrace. And so the notion was get this money to the states and get it out to help victims. And when you're helping 41,000 Rhode Islanders every year, there should be hoops to jump through. That was the point of the program. No hoops, no matter who the president is, no matter what the politics are. The idea is to get the money out. The president is, again, trying to bend the states to his civil immigration will, and he just does not have the power to do that.
Thank you. Our next question is from Jose Castaneda. Jose, you're unmuted.
Oh, hi. This question is for Attorney General Kathy Jennings. This is Jose Ignacio Castaneda with Spotlight Delaware. I was wondering, can you talk to me a little bit more about how these funds would affect undocumented immigrants in terms of the victims' compensation fund for Delaware? I see that there's a box in the application for a social security number. Would you be able to give me kind of a figure of how many undocumented immigrants would be affected by this, if any at all? Yeah.
Sure, Jose. Thanks for your question. The answer is unknown. The reason is we don't ask. So when Congress passed this bill, there was no condition that the victim who was being served by federal funding have to be a citizen of the United States. And that has been consistent. The bill, when it was passed in the 1980s, was passed on a bipartisan basis under a Republican president. And ever since then, it has not been a condition of funding that we ascertain the status of a victim. A victim is a victim, no less so than if they are documented or undocumented. And so the states don't ask that question. Delaware does not ask that question. Victims receive that funding regardless of their status. We know, for example, that murder victims' families who we meet with on a routine basis following the solving of a murder case often say, we don't have the money to bury our loved ones. These funds help those families to bury their loved ones. And it doesn't matter whether they're documented or undocumented. Same with children. If a child, as Peter Neronha, as Attorney General Neronha mentioned, if a child is taken to the advocacy center that exists in our states as a result of this funding, talked with by an expert in interviewing children, has the safety of those surroundings and the services that are provided as a result of that funding. No one asked that child, and that child probably doesn't even know, am I a lawful citizen of the United States? And we don't ask because you are a victim, regardless of your status. That's always the way it's been and always the way it should be.
Yeah, thank you. And then just a follow-up question. How much money or how much funding is at stake for Delaware in this upcoming funding cycle? How much is there threatening to lose?
Sure. The total of the funding in Delaware is approximately $15 million. It's a great deal of money. It funds necessary expenses directly to victims. It funds the services that I have mentioned, whether that's finding a safe place to sleep at night for domestic violence victims and their children. So it funds shelters, and it funds counseling, and it funds the Child Advocacy Center as well.
Great, thank you.
All right, thank you. Our next question is going to be from Morgan Leeson from the New Jersey Monitor. Morgan, you're unmuted. I don't think we can hear you.
Is that better?
Yes, we can hear you now.
Okay, this question is for Attorney General Platkin. What number lawsuit against the federal government is this, since Trump became president again and that New Jersey has either been a lead or co-plaintiff on?
33, and we can get you the list. But thank you
very much.
Thank you for being on.
Thank you. Our next question is going to be from Mikhail Zinstein.
Hey, fantastic pronunciation of my name. Thank you. This is a question. One is related to this case, and one is directed at AG Bonta for another case. So permit me the indulgence. Just so I'm clear on this, the provision here isn't to the provision here regarding status, immigration status, pertains to the victims themselves. It's not saying states have to, for example, abandon sanctuary laws or other things unrelated to the victims. Is that correct? Or is this provision from the Trump administration, in fact, trying to include all sorts of non-victim related immigration issues beyond the status of a victim, immigration status of a victim? Help me understand it.
No, that's incorrect. The policies that this is similar to the cases that we've had to file in other matters where they've conditioned billions of dollars of transportation funding on acceptance of unlawful conditions that require you to impose certain immigration policies. They've done healthcare funding, and now they're using victims. So they're not. Look, I don't think they care, to be perfectly honest, about the safety of any American, but certainly undocumented immigrants. I know that because they've tried to deport in New Jersey a woman who was stabbed in the neck by a domestic partner. And prior to her ability to testify at trial, they put her into ICE custody. So I don't think they really care about the public safety of these individuals, but the goal here is not about individual cases. It's about to force states to abandon policies that courts have routinely upheld, and which in our individual states' decisions, we have decided are in the best interest of public safety. And so they haven't won in the courts. They haven't gotten Congress, notwithstanding the fact that they control both chambers, to change the law. So what do? They try to find political pawns to force states and cities to change their policies. in ways that they can't win through the political process. In this case, I think most heinously, those political pawns are sexual violence survivors, domestic violence victims, gun violence victims, children who have been sexually abused, and we could go on the list.
Mm-hmm. Thank you. Also, I forgot to state my affiliation. I'm with Cal Matters in California. And the follow-up question, this is for Attorney General Bonta, but really for anyone else who wants to chime in. The Newsom versus Trump ruling, we expect it very soon. And so Attorney General Bonta, um, one question is, do you have a plan in place for what would happen if Judge Breyer sides with the government? Will you immediately appeal, and do you have a strategy for continuing that legal fight on the PCA question?
Thank you for your question. As you know, we had our 3-day hearing, our 3-day trial last week, Monday to Wednesday. We went into the hearing confident with what the evidence would show based on the depositions that we took and what the federal administration's military leaders that were involved with the deployment of the National Guard, 4,000 National Guardsmen, people, 700 Marines in LA, what they said. And after all of the evidence was put in and we made our legal arguments, we remain confident. And we think Judge Breyer will issue an order that reflects what the evidence demonstrated, that there was a violation of the Posse Comitatus Act, that the military was improperly on the ground in LA involved in civilian law enforcement, contrary to what the PCA provides for and doing exactly what the PCA prohibits. They were involved in blockades and perimeter support and traffic enforcement and immigration enforcement. There was a data point that came out of our discovery and that we presented at trial that in the days after the deployment, about 75% of the immigration enforcement actions had military involvement, which is unlawful. So we're looking at what's right in front of us, which is an order on the trial, based on the trial and on the hearing. We think that'll be in our favor, and we will assess what we do next based on what the ruling says. I don't want to anticipate every step that we'll take, but we believe in our case. We presented a strong case. I'm very proud of my team that was prepared and proceeded with evidence and law and made a very strong case to Judge Breyer. I know he's taking his time, as he should, to issue a thoughtful order. We eagerly await it. We think it'll be in our favor, and based on what that order is, we'll decide next steps.
Mm-hmm. And one more indulgence. For the other attorneys general on the call, how important is this trial in California, federal court in California, to you all?
Oh, I'm sorry. We actually have a limited amount of time,
Right.
so I have to call on a couple other folks. But for any follow-ups, you can feel free to send it to our office or to any of the other offices that are on this call. We're happy to coordinate that. So we have time for a couple more questions. So I'm going to call on them in the order of hands raised. So next question's from Michael Billow. Michael, you're unmuted.
Thank you. This is Michael Billow from Motif Magazine in Rhode Island. I have essentially two questions. First, what is the actual prayer to the court? Are you asking the court to release funds that have been impounded, or are you asking the court to clear the way for an application process for funds that have been appropriated? And do you plan on asking for a temporary restraining order or preliminary injunction, or exactly what from the court? And I also heard California Attorney General Bonta mention that there had been a prior interaction in a similar vein in California with the first Trump administration. And I would be interested to hear exactly what he meant by that in some degree of detail.
I can answer the first one quickly. We're seeking declaratory judgment that the conditions they've placed on these grants are unlawful, and we're seeking to have them vacated. As it relates to other forms of emergent relief, we obviously keep all our options open.
What I'm asking though specifically, are you asking for, is the money already allocated and they're stopping money moving to you, or are they stopping the application process for the money?
Yeah, that's what I'm saying. They have the grant applications out with conditions that are unlawful. We are faced with the choice of signing on grant applications with unlawful conditions or losing all the money. So we are seeking a declaratory judgment that the conditions they placed on these grants are unlawful and to vacate those conditions. And then I'll leave it to Attorney General Bonta on the second question.
Thank you.
Thank you. In Trump 1.0, this very issue came up, the imposition of coercive immigration enforcement conditions on grants to states in violation of the 10th Amendment, in violation of the anti-commandeering clause that doesn't allow for the federal government to commandeer or conscript or enlist into service local and state law enforcement to do its job for them. And we went to a court. We went to a high court, the Ninth Circuit, and there is a standing Ninth Circuit decision on this issue that is in our favor, that says that our law that promotes public safety and the focus and commitment of local law enforcement in California to work on issues of public safety, to tackle crime instead of be involved in the mass deportation efforts of the federal administration, that law is completely lawful. So we have been there and done that on this issue in the Ninth Circuit. It's decided, and it's completely consistent with Trump to, despite a court order, do the same thing again. That the court order prohibits, or at least provides a strong decision against his position, and so we fight this issue again, and we believe we will win again. But this is not new in the sense that the Trump administration is trying to impose unlawful, unconstitutional immigration enforcement conditions on grants that violate the Constitution, the 10th Amendment of the Constitution, states' rights. And in this case, we're also violating the separation of powers, the spending clause, everything set forth in our complaint.
Yeah, and if I could just jump in here too, there was a district court case in Rhode Island, Michael, brought by the city of Providence, where these conditions were found to be unconstitutional and unlawful. That was appealed to the First Circuit. The First Circuit agreed with the district court. So, as Attorney General Bonta said, regarding the Ninth Circuit, the same holds true here as well. I just want to reemphasize that we cooperate with federal law enforcement. We meet the requirements of federal law in Rhode Island, and I know that's true in my fellow states. This is not about us being unlawful. This is not about us not cooperating. We cooperate with criminal ICE law enforcement. I did those cases. I oversaw those cases as a federal prosecutor and as a U.S. attorney. This is about the Trump administration strong-arming states to take their precious law enforcement resources. You won't find a state police or a municipal police department that is overfunded anywhere in this country and use those precious resources to round up people that are in the country here without documentation, but are not engaged in criminal activity. That's what the administration wants to do. These kinds of conditions have been found to be unlawful before. We're confident they'll be found to be unlawful again. And again, when this is money that is there for the taking for states, it is a very simple application process. And when you're on the non-discretionary side, the formula grants, the money always flows. And so this is the president again sidelining the Congress and taking authority to himself in a way that is consistent with authoritarian government. And it's time for the Congress to stand up and react in the way the Democratic attorneys general are responding. This is not an administration with which you can negotiate unless you're Vladimir Putin, frankly. And so we have to stand up to him, and that's exactly what we're doing.
Thank you. Not seeing any more hands raised, I believe that was our final question. Thank you, everybody, for joining today. Glad to have you on.
Thanks, everyone.